Now it is my pleasure to introduce our speakers today. So we have Tayeb Ali in the middle there, Director of the International Center of Justice for Palestinians, who will introduce proceedings in a moment. Next we have Heidi Dickstow on the right here, Senior External Counsel at ICJP, who has been working on the war crimes complaints that we will be speaking about today. And finally, we have Alice Hardy at the far end there. Alice is a public law expert and partner at Bymans LLP. She has been working on an arms trade export case against the Department for Trade and Business. The case is being led by Global Legal Action Network and Al-Haq, and that work is being supported by ICJP. So without further ado, I'd like to introduce Tayeb Ali, Director of ICJP, to speak. Thank you.
Good morning, ladies and gentlemen. So I'm the director of the International Center of Justice for Palestinians, in short, the ICJP. I was born and raised in Yorkshire, a land where the rugged moors and the relentless winds forged not just the landscape, but the very spirit of its people. It is there, amidst the stern beauty of the north, that we are imbued with an unyielding sense of justice, a compass that guides us unfailingly between what is right and what is wrong. And when we witness the pillars of our great country tremble and falter under the weight of misdirection by those at the helm, we, the people of the north, as we all should, feel the profound call to action. Patriotism extends far beyond the bounds of mere allegiance. True patriotism lies in the vigilance of its citizens, in their courage to hold leaders accountable, to challenge them when they deviate from the path of integrity. Our leaders must be the embodiment of justice, placing the rule of law above all else, above the siren calls of personal financial gain, above the seductive whispers of political ambition, and above any clandestine pacts with powers beyond our shores. It is our solemn duty to ensure that the actions of our politicians are not self-serving, but are tirelessly directed towards the prosperity and well-being of the British people. We stand as guardians of our nation's future, as custodians of our collective ethos. There is no greater act of patriotism than to demand and enforce the standards of governance that our heritage and our future deserve. This is the charge upon us, the charge upon every citizen who believes in the strength and virtue of our nation. It is with this sense of duty that the International Center of Justice for Palestinians formal complaint to Scotland Yard regarding alleged war crimes in Gaza, with complicity from British citizens, including 4 government ministers and officials. On the 12th of January, a meticulous 78-page dossier replete with eyewitness accounts and video and photographic evidence was presented to Scotland Yard, detailing purported crimes within the UK's jurisdiction under universal jurisdiction principles, as well as directly under UK law. The allegations are grave. They include indiscriminate attacks by Israel against civilians and launching attacks with knowledge that such attacks will cause excessive loss of life and injury to civilians. Indiscriminate attacks against civilian property, launching attacks with knowledge that such attacks will cause excessive damage to civilian objects and extensive destruction not justified by military necessity and carried out unlawfully and wantonly. Intentionally directing attacks against protected property, including property dedicated to religion, education, art, science, or charitable purposes, historic monuments, hospitals, and places where the sick and wounded are collected. Blocking humanitarian aid and basic necessities to willfully cause great suffering or serious injury to body or health, and intentionally using starvation of civilians and deprivation of objects indispensable to survival as a method of warfare. the use of white phosphorus in a manner that would render its use unlawful. Our complaint furnishes sufficient evidence for the police to initiate an investigation and to arrest named individuals within the complaint for questioning. In the interest of due process, we withhold the names of suspects at this stage, trusting in the judicial system to carry out its responsibilities without prejudice. However, we reserve the right to review this decision and will not hesitate to challenge any inaction we deem unlawful in the High Court. And we stand ready to defend the integrity of this investigation against any undue political interference, as has been witnessed in recent weeks. We remind those in power that any attempt to obstruct justice will be met with the full recourse of law. The suspects in this complaint include high-ranking Israeli officials and military personnel, and 9 named British citizens serving in the IDF, alongside 4 British government ministers and officials alleged to have abetted these crimes. Our complaint articulates that the named government ministers and officials have accessory liability by the supply of weapons and military support, by providing moral encouragement and providing political cover, all actions considered unlawful in international and domestic law. Now, this is just the first tranche of our evidence and the first list of suspects. Our investigation at the ICJP continues, and we will add further offences and further categories of suspects, including commentators that continue to support war crimes and incite violence in the region. We continue to actively investigate the crime of genocide and the British government's potential complicity in it, and will provide Scotland Yard with further evidence as it becomes available. The testimonies we bring forth are harrowing. A surgeon recounting the loss of his friends, a civil engineer documenting deadly airstrikes in which tens were killed at a time and entire families wiped out, and personal stories of loss and devastation. Each account not only serves as evidence, but also as a solemn reminder of the human cost of this conflict. I'll be presenting some of this evidence in much more detail later today in Parliament. This complaint is lodged not just in the name of justice, but in the spirit of British values that we hold dear, but are being betrayed by our political leaders. The stories of our victims and witnesses, who are British citizens and UK residents, are stories of untold suffering, yet they are also pleas for accountability and the rule of law, which we as a nation proclaim to champion. We will hold the authorities to the highest standard, ensuring that the evidence presented is acted upon with the gravity it demands. Our commitment is to the victims, to the principles of justice, and to the rule of law. We will accept nothing less than a thorough and impartial investigation into these allegations, and we urge the police to exercise their powers with the utmost integrity. As we pursue this course of action, let us remember that it is not just the victims and their families who seek redress, but all who value human dignity and the sanctity of international law. Our pursuit is for truth, for justice, and the prevention of further suffering. Let this be a defining moment in our history, a moment when we stood up for what was right and when we demanded that our country live up to its ideals, when we asserted that complicity in injustice is a betrayal of all we stand for. The strength of our country lies not in the might of its military or the depth of its coffers, but in the resolve of its people to uphold fairness and justice. This will be our legacy. This will be the standard by which history will judge us. That when called upon to defend what is right, we stood up and answered that call with unwavering conviction. In the name of justice, in the name of peace, and in the name of all that Britain stands for, we will pursue this path undeterred. We will uphold the principles that define us, and we will ensure that those who have suffered unjustly will see justice served. Thank you.
Thank you very much to Tayyab Ali for his powerful words there. Next, I'll invite Heidi Dickstall, Senior External Legal Counsel for ICJP, to speak. Thank you.
Well, good morning, everyone. Thank you very much for coming and for your interest in what we are announcing today. Now, Taib has introduced what was filed on the 12th of January. What I'd like to do is go through the law that was submitted with this complaint and was the basis of the complaint, to speak about the sources of evidence and the allegations, the specific allegations that were made in the complaint. So to start with the law, the complaint was made to the Metropolitan Police, and UK legislation provides the potential for suspects to be investigated and prosecuted under the principle of universal jurisdiction for crimes committed outside the UK, but for individuals who are known to either reside in the UK or travel to the UK. And there's two sources of law in the UK that provide universal jurisdiction and on which this complaint has been based. The first being the Geneva Conventions Act of 1957, which allows jurisdiction in the UK for crimes committed by any individual, whatever nationality, for crimes that are committed either inside or outside the UK. This also includes aiding and abetting. The second source that we've used to base this complaint is the International Criminal Courts Act of 2001. And this applies specifically to UK nationals and residents who are subject to punishment in the UK for international crimes committed outside the UK and crimes as outlined in the ICC's Rome Statute. Also covered under this act is conduct that is ancillary to these international crimes, which provides accessory liability, and the applicable liability here is aiding and abetting, counseling, and inciting a person to commit offenses. Now, what's also important about the ICC Act is that it also refers to the jurisdiction of the International Criminal Court, which is applicable and can be used to interpret the crimes that are alleged. And what I'd like to point out in particular is the relevant case law from the ICC on aiding and abetting, which is particularly relevant to what we've set out in our complaints, and specifically which interprets aiding as including practical or provisional material assistance, and abetting, which is described as moral and psychological assistance, taking the form of encouragement and even sympathy for the commission of particular acts. Now, I'm going to move on to the sources of law for the complaint. As Taib had mentioned before, ICJP has gathered evidence of alleged crimes committed in Gaza within the jurisdiction of which falls within the jurisdiction of the UK. This includes public information, evidence and reports from governments, NGOs and international organizations and think tanks, media and other sources. But importantly, it also includes direct evidence from witnesses, many of whom are British nationals and residents. And this has been collected by ICJP during their investigations. So this particular complaint is supported by 7 witnesses based in the UK who've either been present in Gaza and have witnessed firsthand unlawful acts and the resulting harm and have documented those crimes and the impact of those crimes, or from witnesses who have family members present and impacted in Gaza and who have received information from those family members. Their identities are known to the police, but we are keeping the names of those individuals and their identities confidential in order to protect their safety and security. Now, what I'd like to go through is, you've had a short summary of what was included in the complaint, but let me take you through the 4 parts of the complaint. There were 4 areas of crimes which were outlined and for which the police have been given evidence and information. This includes indiscriminate attacks on civilians, indiscriminate attacks on civilian property, intentional attacks on protected property, and I'll come on to what protected property means. And lastly, starvation and the denial of humanitarian needs and necessities. Now, to just start with indiscriminate attacks on civilians, we've looked at the Geneva Conventions Act, which specifically outlined certain crimes that were applicable to this wider category that includes willful killing, making civilian populations the object of an attack, and launching indiscriminate attacks against a civilian population. And then also the corresponding crimes, which are quite similar under the ICC Act as well. So for this, these particular crimes, we've outlined numerous incidents of killings of civilians, which come directly from the evidence of those witnesses who we've spoken to and whose evidence has been gathered. There's also numerous incidents and information and evidence of white phosphorus being used, and also of the targeting of civilians, including very concerning evidence of killing civilians who are carrying out the work of journalists and who are killed during their duties and their work as journalists, and therefore while they were exercising their right to free expression. The second category of crimes that we've outlined is the indiscriminate attacks on civilian property. Again, looking to specific crimes which fall under universal jurisdiction in the Geneva Conventions Act and the ICC Act, including extensive destruction and appropriation of property not justified by military necessity, and launching indiscriminate attacks affecting civilian objects. Here, the complaint goes through numerous incidents of civilian property that is impacted, not only from the evidence provided by those witnesses that ICJP has interviewed, but also from information more widely. And this includes targeting of specific neighborhoods and cities, and including refugee camps. There's quite a lot of evidence of attacks on UNRWA schools as well, and also on bakeries, which overlaps with the crimes concerning starvation, which I'll come on to in a moment. The third area is intentional attacks on property that is protected under international law. Now, this includes attacks on hospitals, attacks on ambulance and health services, and attacks on cultural sites as well. And what I'd like to remind everyone is that under international law, and specifically at the ICC, which is applicable with the International Criminal Court Act, it is a war crime to intentionally direct an attack against buildings dedicated to religion, education, art, science, charitable purpose, historic monuments, hospitals, and places where the sick and wounded gather. Now, what is unique and important about crimes against cultural property and heritage is that it impacts all of those who value the property. The harm touches the community and population as a whole, and this is recognized at the ICC as well. The ICC recognizes the gravity of such harm. It says that the loss of cultural heritage and cultural property sites deprives a community of its memory as well as its physical testimony of its past. It's found that the attacks on cultural heritage are an affront to values of heritage and human identity, which are inseparable to physical existence of the sites that were attacked and harmed. So for this reason, the complaint specifically looks at that wider harm. And I'll come on to, in a moment, to speak about the lens with which the complaint asks the police to view these crimes collectively, and the harm, the collective harm to these individuals, which is extremely relevant to these crimes against culture and heritage in Gaza. The last area of crimes regards starvation and humanitarian needs and necessity. ICJP's complaint last raises crimes relating to the intentional blockade of vital humanitarian aid and other necessities to civilians, including implementation of starvation. And here, evidence and information about starvation and disease going through the timeline of the siege on Gaza and how it has impacted the civilian population is outlined. And this includes the direct evidence of the witnesses as well. The last thing that I wanted to speak about is what I've mentioned just a moment ago about the collective harm. The complaint also addresses collective punishment. It's acknowledged that the relevant provisions for the application of universal jurisdiction in the UK do not enumerate the international crime of collective punishment, so it can't be charged. However, it is notable that the UK legislation specifically raises that collective punishment shall remain prohibited at any time and in any place whatsoever. So even though collective punishment can't be charged as a crime, the complaint raises that when viewed together, each of the crimes, which I've just outlined, the alleged crimes in the complaint, demonstrates the overarching impact of collective punishment on the civilian population in Gaza. And to remember that collective punishment, the basis of collective punishment is that no protected person, including civilians, should be punished for a crime which they did not commit. So what we've asked, what the complaint asks of the police, is that the information and evidence of the alleged crimes outlined in the complaint is analyzed with a view towards the gravity and significance of the harm overall that each of the crimes brings together. The crimes should be considered within the collective harm that they carry. So I'm going to stop there and happy to answer any questions.
Thank you very much to Heidi there for that very detailed account of the war crimes complaint. I'll pass over to Alice Hardy now, who once again is a public law expert and partner at Bymans LLP, who has been working on arms trade exports in relation to the Department of Trade and Business. And that work is being carried out by Global Legal Action Network and Al-Haq, with ICJP supporting it. So over to Alice now. Thank you.
Good morning. I'm talking about a different case that arises out of the same horrific events as those that form the basis of the prosecutions sought by ICJP. It's brought by the Global Legal Action Network and supervised by Bymans on behalf of Al-Haq, a Palestinian non-governmental human rights organisation. Before I talk about the case, I'm going to read a statement that Al-Haq has asked me to read. Al-Haq reiterates that the Palestinian people in Gaza are facing an ongoing genocide. Every facet of life has faced utter destruction. The local healthcare system has crumbled as Israel has declared an unrelenting war on the health system in Gaza, rendering it incapable of delivering essential care to the injured, sick individuals and everyday patients. Israeli airstrikes destroyed 145 mosques, while another 243 were partially damaged. 3 churches have been destroyed by Israeli attacks, along with numerous archaeological and historical sites, as well as significant cultural landmarks, contributing to the erasure of Palestinian history and life throughout Gaza. Nothing and nowhere is safe for the people of Gaza. Al-Haq's case is that the Secretary of State should cease granting licenses and should withdraw her existing licenses to export weapons to Israel. We sent a pre-action letter to the Secretary of State on the 16th of October, but we received no reply. We therefore issued judicial review proceedings on the 5th of December on the basis that, in the absence of a response, we inferred that the Secretary of State had decided to continue granting licenses and to maintain existing licenses to export weapons to Israel. We received the Secretary of State's defence late on Friday, the 12th of January. Al-Haq's case is that it's unlawful to grant licences to export weapons to Israel because it's a breach of the export licensing criteria, which require that licences won't be granted if there is a clear risk that the weapons will be used to commit or facilitate serious breaches of international humanitarian law, or if it's inconsistent with the Arms Trade Treaty. The Arms Trade Treaty requires that states can't authorise transfers of weapons if it would violate international obligations, or if the state knows that the weapons will be used to commit genocide, crimes against humanity, or breaches of the Geneva Conventions. We asked for an order that the Secretary of State suspend licences and cease granting them on the grounds that to continue them would be irrational, an error of law, or a procedural error. In the government's defence, the Secretary of State explained that there have been 4 risk assessments in the period from the 7th of October to the 18th of December. As part of this process, the Foreign Office wrote to Israel on the 21st of November, focusing on a limited number of issues, including 5 incidents identified in an amnesty report from the 20th of October, the airstrikes on the Jabalia refugee camp on the 31st of October, operations in Al-Shifa Hospital, strikes on an ambulance outside Al-Shifa Hospital on the 3rd of November, a strike on a humanitarian convoy reported by the International Committee of the Red Cross, and the Israeli government's position in relation to the evacuation instruction on the 12th of October, as well as its position in relation to claims that Israel has been engaging in collective punishment. It also asked for confirmation whether Netanyahu's statement about restrictions on essential supplies to Gaza represents policy. Israel responded on the 26th of November. It maintained that it was committed to complying with international humanitarian law, unlike Hamas. It set out how its structures enable it to comply with international humanitarian law, and it asserted that it has complied to date. It explained the practices of Hamas, which it said require it to target civilian objects, and measures it had taken to mitigate civilian harm. However, Israel declined to respond in relation to specific incidents that were identified in the Foreign Office letter, and gave no reasons for restricting supplies of food, water, and medical supplies to Gaza. As the Foreign Office risk assessment noted, Netanyahu has said publicly that access to essential supplies will only be given in return for the release of hostages. The Foreign Office considered that this raised concerns as to Israel's commitment to its obligations under international humanitarian law, not to arbitrarily deny access to humanitarian assistance. However, the Secretary of State is satisfied that Israel is acting in accordance with what it believes to be its legal obligations. She explained in her defence that it doesn't follow from the fact that Israel may take a different view of its obligations under international humanitarian law to that of the UK, that Israel is not committed to following international humanitarian law. As a result, the Secretary of State decided on the 18th of December not to suspend licences to export weapons to Israel on the basis that there was no clear risk that the weapons would be used to commit or facilitate serious violations of international humanitarian law. This is despite the copious evidence and arguments set out in Al-Haq's application in relation to the scale of civilian harm, the damage to civilian objects, the targeting of safe zones, expulsions and executions in the West Bank, the serious risk of genocide, and the choice of indiscriminate weapons, none of which the Secretary of State chose to engage with in her defence. She makes no comment on statements by the Israeli Prime Minister, the Israeli President, and numerous senior ministers, including the Defence Minister, which dehumanise the Palestinian people, which conflate Palestinian civilians with Hamas military wing, which deny that there is such a thing as an uninvolved citizen, and which call for the starvation, siege, expulsion, and ethnic cleansing of Palestinian people. She does not respond to our query as to whether it is true that the UK has previously supplied white phosphorus to Israel. She does not engage with the expressions of condemnation of Israel's practices from the international community, including the UN Security Council, the International Committee of the Red Cross, the UN General Assembly, the UN Secretary General and the UN High Commissioner for Human Rights. She ends with the astonishing assertion that al-Haq should be ordered to pay her full legal costs because the claim is not a matter of general public importance. While we've been waiting for this response, South Africa applied to the International Court of Justice for a declaration that Israel cease hostilities on the basis that it is committing genocide against the Palestinians. Without even waiting for a decision, Netanyahu has already declared that nothing will stop Israel, including the courts. According to the Ministry of Health in Gaza, as at the 7th of January, over 23,000 Palestinians have been killed since the 7th of October, of whom over 10,000 are children. Many more face death from starvation and disease. It's horrifying to think of the UK's complicity in this, from the sale of weapons, which has continued without pause, despite the Secretary of State's clear knowledge that Israel is, at best, acting in accordance with what it believes to be its legal obligations. Thank you very much.
Thank you very much to Alice there. So we will move on next to the Q&A section. So I ask that anyone who has a question state their name, their organisation, and which panellist in particular they're asking a question to. So if anyone has any questions, please raise your hand. Yes, over to you.
Could you kindly repeat the numbers of the politicians, UK politicians, and the people, persons who are involved in this space or who are active in this space?
Who is that directed to?
So the number. So the number of people in the complaint are there are 9 British citizens that are accused of travelling to join the IDF in their military operations, and there are 4 UK ministers or officials. And then there are also a number of members of the Israeli war cabinet and Israeli politicians that are in a separate category that are directly involved in command and control structure of what's happening in Gaza.
And over to Ben.
Yeah, Ben Ellery, Time. Just your reasons for not naming the ministers. I know previously you put Sir Keir Starmer, David Lammy, and Ellen Thornberry on notice of a prosecution. So I'm not quite sure why now, when you've got actual ministers who are making decisions, you are not naming.
Yeah, so it's a good question, and I can help with that. So let me just give you the sequence of events, and that will help with with the rationale behind today's decision. So our first step at ICJP was to privately write to politicians that we thought were violating international law or potentially violating international law with their support for Israeli war crimes. And the hope with that was that they would change their rhetoric. And the private communications with various ministers and various opposition politicians didn't work. And so then we issued the public notices. Now, they were notices. They were not accusing politicians of their own individual complicity at that stage in war crimes, but the risk that they ran by their speech if they continued with that and Israel continued with its actions in becoming complicit in war crimes. And so what's happened now is we've entered a different stage of proceedings, and we have actually made a criminal complaint to Scotland Yard in respect of specific named individuals. Now, ICJP operates in terms of its internal protocol in the same way as the police would. And so when the police initiate an investigation, they respect the privacy of the individuals because these are still allegations for investigation by Scotland Yard. And the individuals have the right to privacy at this stage. It's not in the public interest at this stage to name these individuals. in what we hope to happen is that, and we also don't want to interfere with the police investigation. So the police now, in our view, have a duty to open a formal investigation with regard to these ministers in the UK, as well as these British citizens, and investigate them. And that might include, for example, search warrants for their property to establish whether they have information useful in a prosecution. It might involve Schedule 9 stops at a port of entry in order to establish if there's other intelligence as to whether the people might be involved in acts of terrorism under the Terrorism Act. It might involve with arrests and questioning. All of that process needs to be done by the police, and we can't allow individuals to interfere with that. So at this stage, we're not naming those individuals. However, as I made clear in my speech, that if we feel that the balance in the public interest changes and the police, for whatever reason, we feel are not carrying out a proper investigation or refuse to investigate or are interfered with, we may in that case do two things. Do three things actually. One is name the individuals, because at that stage we may make a decision that it's now in the public interest for people to know who these individuals are. Two, we may apply for private arrest warrants with regards to those individuals in the magistrate's court for private prosecution. And thirdly, we might decide at that time it's appropriate to refer those individuals to the International Criminal Court for investigation and prosecution, because and also potentially after investigating the failure as to your UK investigation, individuals that may have failed in that investigation and therefore failed in their obligations in the Rome Statute, they may well find themselves referred to the ICC for prosecution as well. Because the United Kingdom, as a party to the ICC, has an obligation to investigate crimes under the Rome Statute domestically and refer those to the ICC. So at this stage, we don't want to create a situation where we give information that potentially interferes with a proper police investigation.
Thank you, Todd. Yes, thank you, yourself.
Sure, I just want to clear something up as well. With the exception of the 9 British citizens you talk about in the Israeli army who are obviously actively in some way engaged, the ministers you talk about aren't actively engaged, presumably promoting the aims and ends of the war. I assume that the basis of the case is an omission on their part, a failure on their part to actively call for a ceasefire early on. Can you clarify for me, in terms of those individuals,
Yeah.
the ministers concerned, what exactly the evidence points to of their business?
Sure. So I'm going to talk in general terms. So I don't want to give information that will identify any individual. It wouldn't be right to do that at this stage for the reasons I've outlined already. So the Rome Statute, Article 25, makes it an offence to aid and abet or in any other way assist war crimes. So that's straightforward. So what the situation there would be, and I'll just list the categories, for example, if you have knowledge that a foreign state is engaged in alleged war crimes and you continue to supply them with equipment, weapons, or military support, that in itself, that decision in itself would make you liable of the equivalence of the war crime itself. And so the supplying of weapons is one. There's a second part of this as well, and the third part. The second part of this is moral, and the third part, political cover. So where you have a situation where a individual is engaged in a war crime, and the correct thing under the Rome Statute would be to say to that individual, you must desist in that activity because you are potentially or actually committing a war crime, but you do the exact opposite of that, and you say, we stand behind your right to carry out that activity, or you deny that that activity is a war crime, or you deny that that activity is potentially the risk of genocide, and you provide that moral and political support, that in itself is encouragement. And that in itself would be potentially an accessory liability war crime for the individual. And it gets further than that. For example, if you support Israel's alleged targeting of the civilian infrastructure, and I'll say, for example, schools, hospitals, and UN buildings, and you make public statements that there is an understandable, justifiable reason for doing that, that in itself is justifying that war crime and makes you complicit in it. And we can see this in a different way, and it's very relevant at the moment. You see the Metropolitan Police and police forces across the country actively arresting individuals at protests where there is an allegation that individuals are supporting acts of terrorism or supporting Hamas or terrorist organizations. And the police are very quick to do that because they see that secondary liability participation when it comes to terrorism. And it's actually not very different when it comes to secondary liability participation in war crimes. You might argue actually that because of the nature of war crimes, genocide in particular, that it's has a higher level of criminal culpability.
Thanks again. Janine.
I'm just curious what the Met communicated to you in response to the dossier and the information. And also, second question, what has the response been from the ministers and first individuals to that ICJP?
I don't want to disclose conversations between ourselves and the Metropolitan Police, and mainly because the relationship between us and the Metropolitan Police will be ongoing. We're continuing our investigation. We're continuing to support from the outside the Metropolitan Police's investigation. So what that means is that we're continuing to gather evidence at the ICJP with regards to war crimes generally, or alleged war crimes, and that information will be provided to Scotland Yard, and that includes in the complicity accessory liability. And I think any questions that the press have for Scotland Yard should be directed to them. And then we haven't put our potential suspects on notice that the complaint has been made, and partly because it's really important that where the police engage in, for example, applying for search warrants or deciding to arrest individuals, that those individuals haven't had the opportunity to destroy evidence. And we've seen in other inquiries in the UK, not necessarily where evidence has been destroyed, and I'm not making that allegation, but WhatsApp messages, text messages have become really difficult to obtain by the police. Now, if the police want to secure that type of evidence, they can simply apply for a Section 8 arrest warrant, search warrant at a magistrate's court, and go and secure property, telephones, computers, filing cabinet files and such like. And that's something that I would very much hope that Scotland Yard gets to a position of doing, because they have powers that we don't have, and those powers are going to be needed in order to bring people to justice.
Thanks. Janine.
Just a question for Alan. Given the Secretary of State's response in December, what is the next step for
Well, we are waiting for the court to list a hearing, which we hope will take place in the near future, given the urgency. So we're at the stage of proposing directions for how soon that should take place, and I hope that it will be listed and heard as soon as possible.
Right, Ben, for the again. Hi. So I think it was 2 weeks ago, Boris Johnson criticised Scotland Yard's war crimes unit and said that we've got record levels of crime in this country, and the budgets for the Metropolitan Police are woefully inadequate. Is it not? Could there not be better use of police resources in this country than investigating things happening abroad?
So I made comment about this publicly at the time Boris Johnson made these remarks, and what he accused Scotland Yard of doing is politicising a war crime or war crimes investigation of themselves, in fact. And I think that's really disingenuous. First of all, Boris Johnson's political interference in Scotland is politicisation of Scotland Yard, and it's not welcome. And where Scotland Yard, I'll make it very clear, where Scotland Yard has an active investigation or has an investigation, or there is a potential of an investigation, an attempt to interfere with that is a crime, a domestic crime. It's called perverting the course of justice, or attempting to pervert the course of justice. And so I would make it really clear that where individuals at this stage, now that a complaint has been lodged with Scotland Yard, and there is a potential or a likelihood of an investigation, make it clear that there is, because of the fact that the complaint's been lodged by British victims. Any interference or attempt to interfere with that will be a crime. And ICJP, we will make sure that those people are held to account for that. In terms of budget and Scotland Yard's budget, I completely agree. I feel very sorry for the police in the United Kingdom, because under Boris Johnson's government, and when he was Prime Minister, and other governments, the police have had their legs taken away from them in terms of their investigative ability. They've been defunded. They've been their funding has been diminished massively. Now, it would have been good if when Boris Johnson was Prime Minister, he'd have had these thoughts and funded the police properly at that time. And it's also really telling that the Scotland Yard doesn't just investigate the occupied Palestinian territories or Gaza and war crimes against Israel. It initially launched its investigation with regards to Israel proper. And it's really telling that I didn't hear Boris Johnson criticising that investigation. It was only when the situation on the ground unfolded and Scotland Yard became aware of that, and it properly, under its statutory obligation under the International Criminal Court Act, decided that it had to respond to the ICC's request for evidence and collect evidence in the UK and provide that to the ICC, that they took that step. That's a statutory obligation, something that Boris Johnson should know, although he does tend to make mistakes when it comes to law, I have to say, right? Now, as well as that, it's not just the Ukraine itself. The Ukraine itself has been supported by Scotland Yard collecting evidence in the United Kingdom and passing that to the ICC, and I don't see people criticising that either. It's really important that when the police carry out an investigation, and they carry out that investigation particularly on the basis of British citizens making complaints in the UK and all the obligations under British statute, that they're allowed to do their job without interference. And I think that kind of is my full answer to Boris Johnson's what I would call interference with Scotland Yard and attempts to politicise this investigation, which I'd say again are unwelcome.
Thanks. I saw Ola's hand last time round.
Yeah, I'll go into the Arab. So this is a question for Mike. Given that the case going on at the university, if the preliminary verdict comes out from that case, or syndicate the Israelis genocide and breaking these obligations, is that going to change the nature of your own investigation, and is that likely to change the nature of Scotland Yard's investigation?
Well, thank you for that question. What I would say is that it shouldn't. This particular complaint doesn't assert the crime of genocide, but covers a wider range of war crimes, which touch on some of those aspects that were covered at the ICJ. What I would say is that the complaint that was submitted is for crimes. Well, there's a different legal principles that are being addressed at the ICJ. So I think what ICJP would be doing is continuing to investigate, continuing to submit evidence to the Metropolitan Police. A ruling from the ICJ wouldn't impact it, but we'd certainly analyze it and take it from there. Do you want to add?
Yeah, I think it's right to say, Heidi's correct. This is a very specific complaint about very specific crimes and very specific individuals. But ICJP, we've been investigating the crime of genocide for a while. We have collated evidence, some of which you can see spoken about in South Africa's application to the International Court of Justice. And you'll see one of the witnesses that has already given evidence to Scotland Yard, Professor Ghassan Abu Sitta, is mentioned in the ICJ, South Africa ICJ complaint with regards to the evidence that he's given. So you take the genocide complaint, two aspects of it. You have the actions. In our complaint, you have the actions there very clearly. So if you find these actions, then you find that war crimes have been committed, and half of the test for the genocide complaint would be made out. The other side are the speeches or the intent, showing the intent. And with regards to both, the ICJP is still collating evidence to a criminal standard for the crime of genocide. And if we get to the point where we feel that we have sufficient evidence to bring that complaint, we will provide that evidence to Scotland Yard and to the International Criminal Court for the crime of genocide.
Thank you. Any further questions? Yeah.
I just wanted to clarify the reply on the trade minister about the issue of the deals with the Israeli witness and Palestinians.
This is for Alice.
Yeah. So what was the justification? Have they got assurances from the Israeli government that they are not using the weapons
They have no assurances, no. Israel's response didn't deal with the specifics of the incidents that were asked about in the Foreign Office letter. It said that they are committed to complying with international humanitarian law, that they're capable of complying, and that they've complied to date. But it didn't deal with those specific incidents. I mentioned also that they talked about why sometimes civilian objects are targeted, blaming Hamas for being infiltrated into civilian areas. And so it was inadequate in that respect. It didn't deal with any of the specifics of the request, but the request itself was also quite limited. The Foreign Office letter, it simply dealt with quite a limited number of issues. I mentioned the Amnesty report of the 10th of October, the strikes on Al-Shifa Hospital, the strikes on a convoy. It didn't deal with the sheer number of incidents that are described in our application for judicial review, for example. So the government, although it was disturbed by some of the response and found that it didn't in particular explain why the supplies of essential goods are being restricted, and that in particular could indicate a breach of international law, they considered that it was adequate that Israel was acting in accordance with what it believed to be its international obligations.
Thank you, Alice.